Welcome to CarePod, a safe place to educate, inspire, and renew the caregiver. Listen in with our host, Dr. Kipley Bell, as she interviews different experts along the caregiving journey.
So, an important conversation today. I have a very special guest with us, Judge Brian Carlin, the surrogate court judge for Burlington County. And really important to get to the nuts and bolts of wills and estates, planning, what happens when an aging loved one passes. You're near and dear, you're grieving, you're trying to handle all the business, or what do we do ahead of that time? And so I'm really honored that Judge would take the time to sit with us today. So welcome, Judge Carlin, to the CarePod.
Thank you.
So tell me about your journey. That's always our first question here on the CarePod. Your journey in this space, how you got here, what drives you with families, etc.
I was born and raised in Philadelphia. My father was an attorney. My mother was a grade school teacher. I'm one of three children. Obviously, I grew up in the household of an attorney and I started to fall in love with the process of government and the law and how things are done, and hopefully trying to make people's lives better. I followed my dad into practice. We practiced together with another fella for about 28 years before I moved here to Jersey, because I married a Jersey girl, and she brought me here. My practice, because we were a small neighborhood office, was kind of geared towards the people issues, and estates and trust were something that came very easily to me. I had two great mentors, and my father and a fellow named Jim Gannon, who was primarily an estate practitioner. And I really loved that area of the practice of law, because you were helping people, and you were helping them kind of keep the train on the tracks when they've had the loss of a loved one. And as I got better at it and came over here to New Jersey, the practice picked up some more. And the former surrogate George Koch was a good friend of mine, and he taught me a lot of the nuance of how you process and how you deal with this side of the surrogate side of the transactions. I have the good fortune. I have a daughter who's is now the third generation of Carlin.
Oh, that's awesome.
She
that's
practices
awesome.
here, and my two sons did not decide to follow us into the law, but primarily the art of estate and wills practice is one where the law. The law is kind of black and white, and case law, you can look it up. But one of the things is you're dealing with people. And you're dealing with, the little things that come with, having to face the reality of the end of your life and different things like that. For instance, when I started doing this practice, I would go to people's homes because I found they were more comfortable sitting in their kitchen, sitting around the table, or sitting in their living room and talking about this stuff. And if they needed something, they would feel very comfortable to run upstairs and get it out of the strong box or out of the desk drawer or whatever. That personalization, that reaching people, I always felt comfortable that when I finished doing a will for somebody, it was what they wanted at that time. And there's certain things that parents feel they owe an inheritance to their kids, and trying to make them understand that, hey, it's your money. And your kids want nothing more from you than to use your money and enjoy it, enjoy what you've done. And if you leave them just enough to bury you, fine. So there are a number of things that when you're writing wills that nuance comes into play. But ultimately, I served in Burlington Township politics for years. I was a school board member, a councilman, and mayor for 11 years. The opportunity came to run for surrogate, and I won. And fortunately, my friends and neighbors in Burlington County felt strongly enough about my ability that they conferred the honor of electing me a surrogate, and I'm now going to be entering into my third year.
That is amazing, amazing journey. So you mentioned people issues, right?
Yes.
What's the pattern? What's the commonality that you find in terms of prior preparation and what people should be doing now
The,
ahead of that kind of crucial time?
the best advice is you have worked a long time to accumulate, and George Carlin was an old comedian who used to say, accumulate your stuff.
Mm,
And you have the right to give away your stuff, but the one way you control that is by writing a will. The last will and testament is where you sit down and you write a document where you make disposition of your worldly assets. And the nice part about it is there's no right or wrong way to do it. It's what you want. And by doing a will, it allows for an orderly process after you go to do disposition. So it's always advisable for people to reach out and consult an estate practitioner or an attorney and sit down and start to do those documents that kind of move you into the end of your life. And it's not something old people need to be doing. It's something young people should be doing. Every change of life, you should be looking and seeing, do you have your plans in place? Because, when you have younger children, you're worrying about trustees and guardians for the kids. When you're older, you're worrying about, having enough for you to survive on and things of that nature. So when you go to the attorney, you should be looking for basically three documents: a last will and testament, a power of attorney. Now, power of attorney is not always, if husband and wife are alive, it's not necessarily as necessary as if only one of you is alive. And because, generally everybody owns everything jointly with their spouse. And the third one that is to make sure you have your healthcare stuff in place by having an advanced health director. They're not, they're not, they're all documents that you really need to sit down and have a serious conversation about to, make sure you have things in place. And for us in our office, the will, and in my capacity as judge of the surrogates court, it makes things clearer. It makes things, there's not a lot of judicial discretion that's involved, because when somebody brings a will in and they present it to us, I have to sit down, and my primary obligation is to determine if it's a will. And that is it in writing, signed by the testator, and witnessed by two people? That's basically what the law in New Jersey requires from a will. In order to probate it, there's a second step, and that's having proof of execution or determining the will. And that can be done in two fashions. One is a self-proving affidavit that's another page to the will, where the testator, meaning the person who writes the will, and the two witnesses sit down and they sign an oath or certification saying they were there, they saw it, and this is the last will and testament of the testator. Then there's a legal term as a jurat, where the notary sits down and says, the testator and the two witnesses have appeared in front of me. This is their signature. This is their oath, and they sign it. If I have a self-proving affidavit, I don't need proof of witnesses. Okay. If there's no self-proving no self-proving affidavit, then we would send you what's called a proof of witness form. And one of the witnesses would have to sign that before I have a record to be able to exercise my judicial discretion and sign it and say, this is the will and you are the executor. So that's important. And as I said, present it in the light of an alternative. If you don't have a will, your estate passes via what's called the Intestacy Act. It is a statute that has been developed by the legislature and over a period of time, and they set out a plan for who inherits, and generally it's determined by relationships. So in New Jersey, you start with surviving spouse. Then there are children. Then if there's no surviving spouse and children, you go up the chain to see if there's parents, and then off on various branches, where I spend a little bit of time on the whiteboard every once in a while with an estate doing
Yeah.
family trees. So, and the other kicker with an administration is because is you're required to post bond. If
Mm,
you serve as an executor and, for instance, you have three siblings who are also intestate heirs, we have to have you post a bond to ensure they're going to get their 25% apiece. So
interesting.
there's a little bit of cost to that. Whereas when you're writing a will, I probably wrote 800, maybe 800 to 850 wills during the course of my career. Every one of them contained the clause, my executor shall serve without bond. So it's might be a couple hundred to a couple $1,000, but there's a savings to it. So, and in today's age, with everybody, particularly young people, having student debt, the question is whether they're bondable. So it eases a lot of problems and streamlines the process.
So, okay, and let me just reel back a little bit.
Sure.
Family person passes, they have a will.
Okay.
They come to you now. That is the next step, to come to probate.
Yes. What happens is, if someone dies with a will, the first thing you do is you make sure they're properly buried, and that their remains are taken care of either by burial or cremation. We sometimes have issues that pop up with regards to who's the funeral designee. That's why when you go and you talk about doing the will and the attorney, you designate a funeral agent who is able to go to the funeral director, and the funeral director is comfortable saying this person has authority to make plans for the funeral, make determination as to what's to be done with the remains, whether it's going to be the traditional burial or a cremation, and gets to determine where the cremins would go if there was a cremation. So, that's first and foremost. Under New Jersey law, there's a cooling off period. So you're not going to be able to to come in and do a probate or ask for letters of administration in an intestacy until it's 5 days from the date of death for an administration. It's 10 days from the date of death for the will. Okay. Generally, it takes 3 days, 3 or 4 days to get to the burial. You have to have the death certificate. So if you're a New Jersey resident and you're lost a loved one, you would call this office and make an appointment. And you would designate whether it's probate or administration. Since you asked me the question about probate, what will happen is you will be scheduled for an appointment. Right now, we're probably at anywhere from a 2 week to 20-day time out from your call to your appointment. You will be asked to prepare and bring certain documents. When you come to the surrogate's office to probate a will, you will need a copy, the original last will and testament, the certified copy of a death certificate, the death certificate evidencing the death of the decedent. Look at the terms of the will. If it's a situation when you write a will, when you name an executor, sometimes it'll be, I name my wife Susan. And, if in the event she predeceases me or is unable to qualify, my son, Stephen, will be appointed. So if there's somebody in that chain who's deceased, we would require a proof of death for that individual. So in that case, mom's, we would need a copy of mom's death certificate, or if we have something on file here, we would use that. So you'll come to the office, and what'll happen is the young lady at the front office will take your information, give you a clipboard, and let you fill out an information sheet. She will take it back to one of our 3 to 4 probate clerks, and they will start to enter the information into the computer. You'll come back and you'll sit with them, and they'll walk you through the different aspects and what's going on. They'll confirm the information, and then you'll be asked to sign basically two pieces of two items when you come in here that are prepared by staff. One is an application for the probate of the will. All right, and that's a very simple, the decedent died on such and such a date, that someone, you are the named executor. You're asking for, you're asking to have the will probated and be appointed letters of or letters testamentary. Then, there's a list of who the next of kin are. And then you would sign that under oath and say that would like us to grant letters. The second one is your qualification and authorization for me to accept service. That's daunting because people are taking an oath, number one, and then they get a little concerned because they don't know me from, I'm just a name on the door and a signature on letters. Why is the surrogate get service? Well, the reason is if you are the executor and a creditor is suing you or some suit involving the decedent is involved and they can't find you, they serve us. And that's
Mm,
good service for those type of things. But people get really antsy about it, and I have to go explain and introduce myself, and say, hey, I'm the guy who's going to, and we're doing this administratively. I've got no interest in this. And then more importantly, under that document, you take an oath that you will well and truly administer the estate according to the terms of the will and according to law. Once that's done, probate clerk brings it in. We review it. I make sure that everything's in place to be able to enter in order granting, probating the will and granting letters. I will sign that, and the clerk will generally take it to the front and process it. At which point, I generally will walk in and introduce myself to the executor and the family, express my condolences, and kind of just make them feel at ease to know what it is they've been through. If they have any questions about their authority, and remind them that if there's specific questions about the administration of the estate, we can't answer them because that's legal advice and they should consult an attorney. But when we talk about, when we go back to what you started this podcast with, one of the things I have a tremendous amount of respect for my staff is they are a group of young ladies who have tremendous empathy and tremendous that they everybody who comes through through their respective offices, and we do 17 in-person probates a day in addition to what we might do by mail-in or attorneys mail-ins. Every one of them is a personal chapter or episode. They have a great ability to make people comfortable, reach, and they're wonderful listeners. They get things, and they all have there's certain people who come in, and I know which one to play to their strength. For instance, you have an older gentleman who's been married for 70 years. He's been married for 60 years. Suddenly loses his wife, and he's lost. And he comes in and he's wearing a veteran's hat. I know there are at least 3 members of my staff that will stand on the desk and jump up and down if he asks them, because they just understand how vulnerable he is, and they make him feel that he's got control and things of that nature. So that aspect of it, while the mechanics of the legalese is straightforward, and yeah, we have different things where we got to say, we got to get this, got to get that personal contact is something that we take great pride in this office. And as I said, my staff they're as diverse as possible, and different people and come at different ways, but everybody who leaves here feels as if they've gotten their attention, and in that 45 minutes to an hour, they were the focus of what was important to them at that time.
that's so important. It's so important.
Impactful caregiving begins with you. Become an educated and empowered caregiver to best serve the one you love. Impactful Caregiving offers online geriatric certification, personally curated items for the older adult person in our caregiver shop, Geri telehealth options, and of course, your personal dose of inspiration here on the Care Pod. Go to impactfulcaregiving.com.
It's so important because as you know, across many specialties where we lose that interpersonal communication and sense of walking in the other's shoes. So important. So can you define just probate? Like, what does that mean?
Probate means something different in every state. I started my practice in Pennsylvania. Probate was the way that we would refer going to the Register of Wills office in that case and getting letters of administration, or meaning an intestacy, or probating the will. New Jersey, it's a little more black and white. It's actually two different, they treat it as two different distinct processes. Obviously, we just described the probate process. The probate process is merely the formality of presenting the decedent's last will, the decedent's last will and testament to the surrogate's court with a request to have the surrogate probate the will and grant the person who has authority letters testamentary. And then that is the probate process. We talk about asking for letters of administration. That's the different process, that there's no will there. So that's more
Gotcha.
driven, that's more paper, and that's more driven by the familial relationships. So when we have that they're the ones where we frequently have things where people don't always bring us all the information, so we have to get it and send it back and things like that. And just kind of globally, the administration process is one where you would need the death certificate. You would need, basically be able to provide us with a family tree so we can determine who is the first eligible party to receive letters under the statute. And when I say the letters of administration, and then we would ask for once we've determined the relationships, we would ask for, if it's appropriate, things called renunciations. Renunciations are required because, as I said, go back to my example of you have 3 siblings and there's no parent, there's no surviving spouse, so it's 3 children. Each of you has an equal right to serve as the executor or the administrator. In order for only one of you to serve, the other 3 have to say, we agree to that, or we renounce our right. We have to extinguish their right before we can give you letters. If they don't, then the way you get that done is another matter of filing it in Superior Court, and that's probably a conversation for another podcast. So,
Yeah.
once we know who it is, we also get what's called a statement of assets, where you tell us what the decedent owned. That's critical because that's where we determine what the bond is. And if you have to have a bond, we send you out with a list of, the businesses in the area that do bonding work and let you go and get your bond. And when you bring the bond back, we go through the whole process and sign out. The key for both an administration and the most important thing people always ask us for when they come in for either a probate or an administration is the surrogate certificates or the short certificates. And people are told you need a short certificate, and they ask us for that. The short certificate is basically a document that is evidence. It's signed by the surrogate saying that on such and such a date, you were appointed as the administrator or the executor of the estate, and that you have full authority to carry out basically stand in the shoes of the decedent to carry out their affairs. Since we have Willy Wonka's movie out there, your golden tickets. These are the things that you can walk into any bank, to DMV, and you present that in the death certificate, and you carry out. You basically can do with the decedent's assets what they want. What you can close out accounts, you can transfer titles, things of that nature.
So yeah,
It doesn't. Go ahead.
Yeah, sorry to interrupt. So that's what I'm trying to clarify, because what I hear you saying, or what reading between the lines, is it really behooves us all to have all of these things in place ahead of time. And then then we have these things in place, and the probate actually allows you to execute what the will has said, correct?
Correct.
Okay. And so then now the former would be you're not prepared, or whatever the reason, there was no delineation of tasks or designees, etc. And so now you sit with legal, you get all of that straight, but that can be very involved depending on the family, the siblings, etc.
It's a more complex process, and you're correct. People react differently on the death of a loved one. We all grieve differently. So, you hear all kinds of different things. No, I'm not going to let you serve because I'm the oldest, or B, mom loved me more than you loved you more than me, or I love me more than you. You hear,
Yeah.
you have all those things, and it's almost borderline issues you hear in family court that we hear in the probate side, except the principal is deceased here, and they're a party in the family court. So the normal family squabbles and the normal interactions are very, very common here, and like I said, we're really doing a 101 level discussion,
Yeah,
and
yeah.
there are just so many different little nuances under the statute that how people can derail. Even if you have a will, they can derail the probate process by trying to challenge the will, and that's done by a process called a caveat. And a caveat simply says, I object to the filing of the will. It gets filed here. I, as the surrogates court judge, lose jurisdiction, because
Mm,
once that is filed, the judge in Superior Court decides whether the will should be probated, and then they can prove, the person challenging can prove undue influence, the lack of terms, and hopefully nobody will ever have to address them if the wills are done right. So,
ahead of Yeah,
it's
yeah.
it is a process, and as I said, from our standpoint, we'll do whatever people bring to us because that's our obligation under the law. For them and for the people coming to us, it is much easier and much clearer if the testator has set forth what they want done, and they've spelled out specifically for their executor how they wanted to do it. That allows people who have lost kind of control because of the death of the loved one to have some certainty and some control that allows them to get closure maybe a little easier, what is going on. And the nice part is whoever the executor is can say, yeah, that's what dad, mom, brothers, sisters wanted. And I encourage, as I said, I encourage young people to get wills because we see decedents from 25 to 105 come through this office. So you never know.
Hmm.
And, if you have, a family or you have a wife or, things like that, it's important because, some of these fatal diseases strike younger and younger these days. And so, it's always good to be prepared and it's always good to do it. I also recognize that sometimes it is incredibly difficult for people to do it and come to grips, but it's a conversation that everyone should be having, and
Right.
and I think as we have generations coming behind me, I know my kids are very conscious about their finances and what's going on and how to do that, and they've gotten married and they're working through those things themselves. They're also of an age where they're indestructible and
Hmm.
or think
Hmm.
they're indestructible. So but they're getting to it and they're discussing it, and it is important to do so.
Yeah, and it's important, I was just having that conversation with a friend of mine the other day that, you finish all your education, it's like, I'm gonna buy the house, I'm gonna do the things, but in addition to those things and the before you do's is to have that conversation with your parents when they are more agile and mobile and still employed and all the things to say, what do you want this chapter to look like? Like that's a conversation to have as a younger adult.
I agree, but do so cautiously
Hmm.
because parents have personal great deal of pride. I have a mother who's 88 and she's fiercely independent, has always been. And you have to pick and choose your time for those conversations because
Yeah.
they want that independence. They want it, so you have to frame it kind of delicately. But I think most parents will raise it with their children before the children have an opportunity to raise it with the parents because you know that conversation up is one where you're threatening and suggesting that mom and dad may not. So you really have to to temper it. But if you can have that conversation, by all means do, because it makes life a little clearer. But it all, and it it allows everybody to understand that when that will is produced and presented to the court and probated, that it clearly expresses the true intent of the person who wrote it.
So question, so the will is not sufficient in and unto itself. Is that correct?
The last will and testament, if you're alive, the last will and testament is just your last will and testament. It's not, has no binding authority, has nothing. So it becomes final when your time on this earth has terminated or finished. So that's the will you have. And you can't take a will to a bank and say, this is the will. There's a process in which we go through the orderly process of closing out someone's affairs has to come to us or Superior Court, and we grant letters probating the will.
Okay, yeah. So that is a very key point for the audience, that just simply having the will, having it notarized, sitting with the legal, that is a major step, but not the final step. So now loved one has passed on. It needs to be formalized, probated in order to execute the wishes of the aging loved one or the loved one that's passed. Yeah. Gotcha. What do you say to people that say, listen, I don't, moving kind of on to estates, et cetera, I don't have anything, what do you say to those people?
First off, that tends to be a lawyer question to a certain extent, because you never know what assets might pass via a will. One of the things we see commonly today is unclaimed property. We have people who died in 1999 come in here to get, letters of administration or a will to be able to go to the state and claim unclaimed property. And so, there's always something out there, and that question that you raise are people who generally have some of the largest estates you'll see, but their sense of humility of, I worked hard, I got this, I'm living comfortably. The suggestion is go talk to somebody. A lot of lawyers will do initial consultations for free now, and just go and say, hey, this is what I have, this is what's there. And, it can't hurt to say it, but, a simple will is 2 pages. I give, devise, and bequeath the residual remainder of my estate, wheresoever we're situated, to my wife or my husband. And if he or she doesn't survive me, I want it to go to my 3 kids. And I appoint, my husband and or wife as the executor. And in the alternative, I appoint my daughter or son. So you at least give yourself something that if there is something there. And remember, you also have a lot of people who might perish in an accident or as a result of, some negligence somewhere, that those could become big assets. So you while you don't have it today, it doesn't mean when you go, you're not going to have something there that, has some value. So I say to everybody, if you're thinking about it, go consult with a professional, a consultation. And find out what the consultation fee is, talk to them, and, then you at least feel better. Know what, and more importantly, you're making a knowing decision as to what your parting gift is going to be to your children or family. Meaning that, are you going to send them with a will with an orderly process, or are you going to make it a little more challenging in terms of an administration?
Yeah.
Join the private Facebook community, International Caregiver Exchange, a global community of caregivers. Come on in and catch a glimpse of my own personal caregiver journey, all while being educated and encouraged. International Caregiver Exchange.
Yeah. So in this technologic society, have you seen or what have you seen come through? I've heard these kind of whisperings of, who's going to take over your Facebook page, or, those who have small businesses or who are entrepreneurs that have, a social media legacy. Have you seen any nuances around those topics and that
Yes.
intellectual property?
Yes, we have seen that. And when you have social media, the biggest issue is being able to get to photographs and those type of legacy type things on a website. It's evolved over the past several years. There was a federal act that gave a designee the authority to go and access their account. A lot of people will share their passwords with a loved one or their executor so that they can just act as if they never passed. New Jersey has adopted a statute that says if you're the executor of or an administrator of an estate, you have certain rights under the law to be able to go and get information. You can't get total access to the social media account. You can get those historic things like photos, things like that. But I mean, if you want the text messages between, your brother and a friend somewhere, you're not going to get them. Police have difficulties getting them. But one of the things that it allows us to do is if there is a social media account and they have the password and or at least they know what the account is, we can take the act and issue an order saying that you as the executor are the designee to be able to receive information from the social media account. Businesses are a little more complex because a lot of people own the businesses in a corporate setting, and a lot of this, the social media companies have gotten are probably faster than the legislature in addressing these type of issues. So one of the things you should do is for each of your social media accounts is look at the terms of your contract, look at the terms of whatever your agreement is to be able to be part of the platform. And that you might be able to dictate in there who should be getting you're getting access. So,
To manage it.
they do that. But the corporate side, again, anybody who has a small business or is as successful or any type of small business should have some kind of will and some kind of planning in place to for the to allow the corporate existence to move forward, buyouts and then there's different techniques lawyers will use, like life insurance policies to be able to buy out interest that's something you really do need an attorney to go talk you through. But at the social media, the social media area is expanding. One of the issues that's currently pending before the legislature is a concept called electronic wills
Mm.
where a will is executed much like people are executing real estate contracts, where you've got an electronic signature. That is an interesting discussion because for back to the English common law, one of the ways you could determine the intent of the testator in determining whether a will was valid or not was the signature of the testator. There's nothing that says this is what I want without that we refer to it as a wet signature. But I could sit here today and I could send something and prepare a will and have my signature look exactly like yours because they're all being produced by a program that has a limited number of signatures. So it for me, I haven't seen enough that I'm comfortable suggesting. I understand it provides something more than requiring the good old fashioned signed originals. And I know people get frustrated with us because we tell them we can't probate a photocopy. You have to go to court to do that. But the fact of the matter is our obligation is to make sure when I sit down and I sign an order probating a will, that I am confident that it is the will of the decedent. It's their act and it clearly expresses their intention.
Yeah,
So yeah,
and you
that
do it
is
with honor, clearly, and
thank
your
you.
staff, which is
Yeah,
that's amazing. It really is. It's
thank you.
transparent leadership. You're my kind of judge.
Thank you. Hey, like I said, I take the, I'm a private or public servant, and you heard me use the expression before. I don't get too wrapped up in the title or the position because I know I'm just renting it for 5 years. And
Right?
if I'm going to continue to do it, it is going to be because of the consent of the residents of Burlington County to say, hey, you've done a good job and we'd like you to have you continue. So as I said, I grew up with an old time a lawyer and politician who taught me that when you're in these positions, you serve the people and you try to treat them the way you would want to be treated if you were in their shoes.
That's it. That's it. It's a privilege as a public servant in a different manner.
Mhm.
It's an honor to be able to enter into the space of a family and hear their stories and walk in their shoes and have the ability to utilize your training to affect change.
Mhm.
So it's important.
Yep.
So close us out. Give us the top 10. We're starting out the new year 24 with this episode. Top 10 things to do to get your house in order.
To get my house in order?
Yeah.
Well, the first is to follow the guidance. The top one is to follow the guidance of the lady I've been married to for 33 years. She has navigated me successfully through the last 33 years, and I suspect I'm hoping she's going to continue to do that with me. In terms of what we do here, as I said, we're customer service oriented. We're going to try to continue to live up to that top standard. I am a proponent of training my staff, so I'm trying to go across the board where everybody, this office, we do a lot of things. We do the stuff regarding decedents. We also do guardianships. We see people have a lot of, particularly now that we're identifying young people with disabilities earlier in life, and older people are living much longer. We have seen a great growth in adult guardianship proceedings. Younger people, because once they turn 18, they're effectively reach the age of majority and able to make decisions for themselves. So, parents are coming in and doing those applications. You have people who are older and obviously with Alzheimer's and dementia and the many different disabilities that come as we age, maybe not so gracefully, but age. We have somebody who has to stand in their shoes and help make decisions for them. So we do a lot of adult guardianships. We do, we're the record keeper for the county.
Mm.
When wills are probated here and they're trying to track title for real estate and everything like that, we're the official office. This is the office they come to get all that information to confirm chain of title and things of that nature. We do the guardians or minors work where we hold funds for minors until they turn 18 in a segregated account. So we're kind of the utility infielder of the court system where, all these things come here. But that's a long way of getting to my point. I want my staff trained in all of them. In the past, it was easy to kind of say, you're this, you're that, and what happens if somebody's out for a long period of time, suddenly you're juggling and dealing. So I've wanted to develop a bench here where if somebody's there out, somebody else can step in, and we have the ability
Cross train. Yeah.
to do that, and that's more of a management thing. But at the end of the day, it's so that we can continue to provide services to the residents. It's good health and those things. I mean, I don't think I can get to 10 to be really, really honest with you. But as I said, at its core, it starts at home with me
Yeah.
and my family, and then we come here and this is for lack of a better term, a second family. They're just a little more different and a little more complicated.
Yeah.
But they, despite their differences, they are a great team, and we try to do what we can for the residents of Burlington County to provide them the best services possible. So,
Yeah.
you know,
So when I say, I guess, top 10 for the takeaways, I should say, for
The top
what
10
you
to
want.
the takeaways?
Yeah,
That's
for the
first and foremost, have a will if you can. Go and start to plan. I know people, we become planners. So go out and consult with a professional or look online. You can get them online, but as I said, the online is kind of they're more, boilerplate. Whereas if you go to an attorney, you sit down and you have a human being, you talk to him or her, and you know that those little things are tailored, for what you want. So that's first and foremost. When you come into when you lose a loved one, it is a process. You get through that initial stage with the funeral director and the burial, and you give them closure. And at that point, you start to come to us. And I hope we've given you an understanding of what you should expect when you come here. As I said, we operate with sympathy, empathy, and compassion. Sometimes not as good as we should, but that's what you should be expecting from us. We try to answer questions as well as possible. But as you said, as you go through the process and you're thinking, look at who's going to control your funeral. In New Jersey, you have the right to buy prepaid burial insurance. You can go through the funeral directors to do that. You can also kind of get an idea for what you would like planning wise. I know in Pennsylvania, they'll actually let you set up a prepaid funeral. But again, it's distinction between your states, and I know you've got a global audience, so you got to look at what your state's law is. But even if you don't, make sure and particularly if there's no surviving spouse, designate somebody that you want to make those decisions for you. And because it can get messy, it can get difficult. With regards to your social media, look at what the terms of service are with your provider. It's interesting. There was an article the ABA put out that one of the things they talked about was share your password with the person you want to know. Well, we've spent. I think I'm a little older than you, but I've spent a lot older than you. I've spent my life with people telling me protect those passwords, and then and as we're accounting for death, you're looking at let so and so know what your password is. That is a challenge. So you need to find what your comfort level is with that. And the last takeaway is look. There are mechanisms that are that are set out a process for you doing wills and closing things out and what happens after your death and how they do that. But the most important thing that I took away from 35 years of practicing and doing this is when you sit down and you do your will. I don't want to use the term there's no right or wrong way to do it, but what you want at the end of the day is that your affairs are in order. So that if you have that tragic accident or you just, your time here on earth is finished, that you will be comfortable going to your final resting place with the knowledge that you have things in place the way you want them. And that's kind of the goal. Those of us who remain after you will try to make sure that the road is smooth for your loved ones so that they can grieve appropriately and get some closure.
Absolutely. Such an honor to sit with you, and so thankful that you took the time
Thank you.
to share. It's really an example of how leaders should be. So I appreciate you.
Okay. So, thank you for the invitation.
Thank you
everybody
so much.
have a wonderful remainder of the holiday season. And have a happy and blessed New Year.
Absolutely.
Great information right from the source. For more information on how to caregive like a boss, check out impactfulcaregiving.com. Want to be a guest on the show? Contact us at carepod@impactfulcaregiving.com.